Hey everybody, John Skiba here. Welcome to Thursday night here on the Consumer Warrior YouTube channel. Each and every Thursday night we're here answering questions, going over topics of all things debt related, whether it's debt collection lawsuits, consumer bankruptcy, wage garnishment. We deal with all the horrible things out there as far as debt goes. Again, my name is John Skiba. I'm a consumer bankruptcy attorney and a consumer, I guess you'd call me a consumer protection attorney. I deal specifically with defending people who are being sued by their creditors. And I'm here in the state of Arizona. You can see my contact information below. If you need help, legal help, and you're in the state of Arizona, I can help you out. Unfortunately, if you're not in Arizona, I'm not licensed anywhere else. I am, like I said, creating a network of attorneys that do similar stuff that I do, because I know they're kind of hard to find. And you'll also see there in the chat section links to Solo Suit, who's one of the sponsors of our weekly live stream. I'm actually getting ready to do a kind of a joint live stream with one of the founders of Solo Suit. They do awesome stuff with technology and helping you put together things like debt validation letters, answers to debt collection lawsuits, and they even work with debt settlement. And you'll also see my Consumer Warrior University, where I have a lot of deep dives, templates, forms on how to deal with a lot of these debt issues. So I give my disclaimer like I do each and every week, even though, we're talking debt related things here. And if you do have questions, the way we do this is we have you put it in the chat section. I'll put it up on the screen, but you should not take this as legal advice. This is just some guy talking from his office on YouTube. So take it for what it's worth. So, all right. And we already have some questions, so we can dive in here pretty quick on that and start doing that. But if there are any questions, go ahead and put them up in there. I'm happy to see what I can do. Sal, back at it. Okay, Sal. So this is an ongoing, it's an ongoing battle. And that's one thing that anybody who's dealing with debt collection lawsuits, it's not something that's resolved quickly. I tell people the problem didn't happen overnight, and the solution's not going to happen overnight, and the wheels of justice move very slowly in civil cases. So you just need to be prepared for that. So Sal said, I turned in the court a law calendar for a hearing on December 1st, along with my proposed order to set aside the default judgment for improper service, no certificate of service on file, no record of certificate of service on file. So based on the rules of civil procedure, the judgment is void. Court won't have jurisdiction if there's no certificate on file, correct? Also, one more question. If the judge granted my proposal, is there a lien against my property? Is it removed automatically? And I think there's one more. We'll go down. Also, if the judge, okay, no, that's the one I got. So, well, let's go through these questions you had first. So if they didn't serve you correctly, if there's no certificate of service on file, will the judgment be considered void? So they do have to prove, they bear the burden, excuse me, of proving that they served you. So they filed the lawsuit. They've got to have a process server, constable, sheriff, whoever it is, drop off the complaint in the summons so that you have a chance to respond to it. And if they don't do that, if they don't serve you, then the court doesn't have jurisdiction to hear the case. And so it's technically void, and they should set aside the default. Now, the way that the plaintiff proves that they have served you correctly is that they have to file a certificate of service. Sometimes it's called an affidavit of service, where the process server or whoever did the service is attesting that the information is correct, that they went by your house on such and such a date at this time. They usually even have like a physical description of the person. They've got to have some proof that they actually served you. So if they didn't file a certificate of service, then the issue is, how do they prove that you were served? Now, if they, so what'll happen is you file your motion to vacate that default judgment. If they file a response and say, no, we did, here's the certificate of service, it just wasn't filed, a lot of courts are going to take that. They're going to allow it, even if they filed it late. But if they come and they're like, hey, we don't have it, then the court they should set that aside. I say they will set that aside. They should. If there's no proof of service, they've got to serve you before they can enter any type of default judgment. So follow the other question. It says, if the judge grants your proposal, if they grant your motion to vacate the default judgment, is the lien against your property removed automatically? So it kind of depends on, so it sounds like, I think you're in Arizona, I think you said before. excuse me, in Arizona, what they do is if they get a judgment against you, so in your case, they got a default judgment, they then can record it with the county recorder, and it acts as a lien against any real estate in that particular county. And so, like in Arizona, there's Maricopa County, there's Navajo County, Pima, Pinal. If you have a home in, let's say, Pima County, but the judgment's in Maricopa County, they have to go file that judgment with the county recorder in Pima if they want a lien against your property there. So if they've done that, and then you get the judgment vacated, then they need to file a release with the county recorder. So the thing with the recorder's office, things don't just go away. They're always there. But, they'll show, like, if there's a judgment, it can show that it was satisfied, or they can show that it was released. So there has to be, like, essentially a follow-up document to it. And if you do get the judgment vacated, I mean, what you can do, I can tell you this, Arizona's county recorder system, particularly the Maricopa County recorder system, as far as its ability to search for things, is awesome. I've spent a lot of time searching documents in county recorders' websites all over the country. And Arizona has one of the best. It's very easy. You can just plug your name in and you can look it up and you can see it. You can actually see the document. They don't make you pay for it. You can just see it. You ought to go check the county recorder in your particular county and see if it's there. That's how you're going to be able to tell if it's if there is. And if there is and you get it vacated, then yeah, you're going to probably have to ask them to do some type of release on it. So, all right, let's see here. Let's see. Derek says demanded arbitration versus Midland being a junk debt buyer. Just in case they follow through, thoughts, chances, can I ask for terms between Midland and the creditors? Hand pink waving. Is it normal for them more? Oh, sorry, different question. I thought this is a follow-up. So yeah, I mean, I always say this: if you file a motion for arbitration, you need to be prepared to move forward with arbitration. I think if you're filing it and then you don't intend to move forward with it, you need to be proceeding in good faith. And so you need to be ready to do it. Now, the benefits to going forward in arbitration, like I said, I work in courts that deal with, short of like criminal and like speeding tickets, these debt buyer cases clog the courts in Arizona. So the judges are used to seeing them all day long. Well over 95% are not represented by counsel. Most of them go to default. And so they're just rubber stamping these things all day long. I think that there is some benefit to getting kind of a fresh set of eyes on this by getting someone through like the American Arbitration Association. But you need to be prepared to be able to present the same defenses, particularly like with Midland, a junk debt buyer. They've got to establish not only that there was a contract, they've got to establish that you breached it. They've got to establish what their damages are. And then they have the added step that they have to show that they were transferred, that your specific account was transferred from Midland or from the original creditor over to Midland. So you've got to be able to prepare. And that's what a lot of my tutorials at the Consumer Warrior website are for, is we kind of do a much more deep dive. A lot of this stuff is in my YouTube channel. My courses have some additional information on that as well. So, all right, let's see here. NK says, is it normal for a mortgage servicer to show closed on a credit report after a Chapter 7, one payment behind? Okay. NK, this is one of the more frustrating things in a bankruptcy attorney's life. Here's how it works with Chapter 7 bankruptcy, and it kind of gets into the weeds of it a bit. So, but if you file a Chapter 7 bankruptcy, technically, your debts are all discharged. They're eliminated. There's nothing owed. And so when you get through with your Chapter 7 and the discharge comes through, it's not uncommon, and frankly, it's probably correct, where all of your debts, including car loans, mortgages, and all that, they're going to show zero owed. No money is owed on your debts. And this freaks everybody out because they're like, hey, I didn't mean to include my mortgage in the bankruptcy. I want to continue to pay it. And you do need to continue to pay it because there's two parts to a home loan. There's the promissory note, which has the terms of what you're going to pay, the loan. And then there's deed of trust or security document. The deed of trust is the document that ties the home and the promissory note together so that there's collateral with the loan. Your Chapter 7 bankruptcy eliminates liability under the promissory note, but it does not eliminate the lien on your property. It doesn't get rid of that deed of trust. And so if you are not paying your mortgage after a Chapter 7 bankruptcy, they're going to come and foreclose on your house. So the practical effect is you just need to continue to pay on your mortgage if you want to keep it, and you'll pay it off as normal. But your credit report will show that there's zero amount owed. Now, let's say you go through a Chapter 7 bankruptcy, you get your discharge, and then 2 years from then, something happens and the house goes into foreclosure. They foreclose on the house and they don't get enough to pay off your first mortgage. Your bankruptcy does offer some protection because it eliminates the debt's already been eliminated. They can come take the house back, but they're not going to have any money. There's nothing they can go after, no deficiency balance that they can come after. So it is normal for it to show zero, but you're still going to have to work with them to try to get that squared away. So what happens if they sell large assets like cars and boats prior to filing? I'm trying to see if this was prior to filing bankruptcy. There we go. I thought, man, I'm not getting this. So what happens if you sell large assets like cars, boats, or RVs prior to filing bankruptcy? It's not a problem in and of itself to sell assets prior to filing a bankruptcy. If you have a boat and you sell it and there's a loan on it and you pay it off, that's fine. Let's say though that you have let's say you have an RV and it's paid for and it's worth $15,000, and a month before bankruptcy you sell it. There are two scenarios. One is you sell it to your brother for $1,000, and the other one is you sell it on OfferUp, Craigslist, whatever. You sell it on some online platform for $14,000. So it's worth $15,000. You're selling it to your brother for $1,000, or you're selling it just to the general public, and it's $1,000 less than that. One's going to cause problem in your bankruptcies. The other one is not. The first one, if you're just transferring it to your brother for less than what it's actually owed on it, that's going to cause you some problems. It's going to be considered a fraudulent transfer, essentially, where the bankruptcy trustee can go in and unwind that transaction. They actually go and they get it from your brother, bring it back in, sell it, and distribute the money to all your creditors equally. And the way that they go get that from your brother is they sue your brother, and it makes things like next week, Thanksgiving, super awkward if your brother gets the federal lawsuit. So you don't want to do that. So it needs to be an actual sale. It's got to be sold for approximately what it's worth. It's got to be, money's got to change hands. You got to change the title. And that's why in the second scenario, if they're selling if you're selling it to just someone in the public for you're basically what it's worth, not a problem. As long as it's an actual sale, money changes hands, you want to document it, that's not a problem. So the kind of the collateral issue, the consequences of it though are then, okay, now you have a bunch of cash. And generally you can't go into a Chapter 7 bankruptcy with a ton of cash. Now it's changed a little bit because of a year ago in Arizona, Prop 209 passed. This was the new thing that deals with, the homestead exemption. It also changed the exemption as it relates to bank accounts. Now an individual in Arizona, $5,000 in your bank account is exempt, is protected. So you can even file bankruptcy as an individual in the state of Arizona with $5,000 sitting in your checking account, and they can't touch it. If you're married, it's double, $10,000. And that can be so each spouse can have one account with 5, another account with 5. You can have 10 stacked in one account. So the one thing you can't have is like 10 accounts with $1,000 in them, or 5 accounts with $1,000. It's got to be, you each get one account with up to $5,000 in it. So you could have more, but the issue, kind of what I'm saying there, is if you sold the RV for $15,000, then you got rid of your asset problem. Now you got a cash problem, and you've got to figure out what to do with it. And you can use it for general living expenses, but there's not a lot of provision, at least in the state of Arizona, for savings when you're going into a bankruptcy. But this new Prop 209 stuff does make it quite a bit better. It also changed garnishment laws. I was just dealing with this in my law practice here in Arizona today, where this person got hit with a wage garnishment. And it was a little comforting to see because the Prop 209 reduced the garnishment from 25% down to 10% of your net wages. And the creditor was doing this one right. They were just saying, we'll take the 10%. Because I was having creditors put the 25%, and it wasn't That's not what the law is. And for some reason, the courts were pushing it through unless you objected to it. So now we're starting to see that hopefully more, particularly we're a year out now from when Prop 209 was passed. So we're starting to see that. It also raised your homestead exemption up to $400,000 of equity is protected, which is gigantic. So hopefully all of that helps a bit. I think we're going to end it a little bit early tonight. So last call for questions. I am going to say next week. So I'm recording this on, what is today? November 16th of 2023. Next week is Thanksgiving. That's the day that we're, we used to do this on Thursday evenings. I'm going to be out of town and not available. My wife would not be happy with me if I was breaking away from Thanksgiving to do my live stream. So maybe I'll record something ahead of time and release a video, but hopefully you're with your family too and can take some time and not be stressed about this constantly. I know that's hard. Money issues are something that it affects sleep. It affects everything. But I feel like there are, sometimes there's these holidays where you can just set aside the day and say, you know what, we're going to block the world out for a day and not think about money and everything else and just try to focus on family and all those important things. So no live stream next week, but I'll try to put something together. I've got a few more videos that we're editing right now. They're going to be pushed out pretty soon. So, all right, everybody. Hey, thanks for checking in tonight. Again, check out the link over there and the things with Solo Suit, as well as with the Consumer Warrior University. That's going to provide some additional help. And of course, if you're in the state of Arizona, give me a call. I'd be happy to set up a call, talk to you and see how we could help. Hope everybody has a good Thanksgiving. We'll see you in 2 weeks.